welcome to the 272nd edition of Legal Empowerment Through Interaction lecture series. We continue with the journey of empowerment and enlightenment by having constructive discussions on different nuances of law. Today, the topic itself is recall of summons by Magistrate Impermissible, Adalat Prasad versus Rooplal Jindal, 2004-7 SCC 388 a critique. I don't want to impinge upon the time or the subject, but the pre-session meeting with Prem, I thought I'll just share some thoughts. Till the three-judge bench of Adalat Prasad said that the magistrate is not having authority to recall the summoning order, and he has to take recourse to section 482 CRPC, which later in Subramaniam Seduraman, that is AER 2004 Supreme Court 4711 was upheld. That's another three-judge bench. Till then, we had KM Matthew, that's AER 1992 Supreme Court 2206. So today, we'll be exploring and debating and discussing on the different facets of this specific topic to deal to lead the deliberation and to take us through the different decisions and the legal points. We have the speaker of the day, Virupaksha Gouda sir, and we are privileged with the presence of Justice V. Ramkumar sir, Justice M. V. Ramana sir, and all of you wonderful participants. So without wasting any time, may I request the speaker of the day, Sri Virupaksha Gouda sir, to please.
Yes. Thank you, sir. Good evening.
Good evening.
Good evening to my Lord Justice Ramkumar Garu, Justice Ramana Garu, Sir Shyam, Ray, and friends. Sir, having seen the discussions going on in the group for the last 1 week or 10 days, I was a little hesitant to accept the assignment. But I was inspired by the words of Justice Ramkumar that my final answers also need not be right. So error is human. So I have taken up this assignment. As His Lordship pointed out, the shortcomings of the arguing counsels are also equally responsible for many of the wrong verdicts. Sir, we have this Adalat Prasad case where the question of any discussion regarding summons case was unwarranted because it is a case under 420 IPC, which is a warrant case. Since it was a private complaint, so the procedure could have been private warrant procedure was required to be followed. So there was no question of any reference to 203 or 204. But the learned judges have referred to the provisions of summons case and held that the order of recall of summons is not permissible. So before we refer to this Adalat Prasad case, it is necessary to go back to AER 1992 Supreme Court 2206 Matthews case, Claim Matthew was the state of Kerala, which was a case under defamation. The chief editor of the Malayalam Manorama paper magazine was one of the accused. His contention was that there was absolutely no reference to any allegation. There was absolutely no allegation against him in the complaint, and as such, he was not required to face the trial, and therefore his application for recall of the summoning order may be considered. The magistrate dropped the proceedings off even after recording a plea of guilty. The said judgment was set aside by the High Court, holding that the magistrate has no power to drop the proceedings in a summons case. Now, this is what the observation of the Honorable Supreme Court. And the High Court seems to be too technical in this regard. If one reads carefully the provisions relating to trial of summons cases, the power to drop proceedings against the accused cannot be denied to the magistrate. And but the need lower down, but the need to try the accused arises when there is allegation in the complaint that the accused has committed the crime. If there is no allegation in the complaint involving the accused in the commission of the crime, it is implied that the magistrate has no jurisdiction to proceed against the accused. It is open to the accused to plead before the magistrate that the process against him ought not to have been issued. The magistrate may drop the proceedings if he is satisfied on reconsideration of the complaint that there is no offense for which the accused could be tried. It is his judicial discretion. No specific provision required for the magistrate to drop the proceedings or resign the process. The order issuing the process is an interim order and not a judgment. It can be varied or recalled. The fact that the process has already been issued is no bar to drop the proceedings if the complaint on the very face of it does not disclose any offense against the accused. Therefore, the lordships have taken a view that when the complaint itself does not contain any allegations making out any offense, there was no need to proceed against the accused. This judgment may be contrasted with an earlier judgment of the Delhi High Court reported in 1989 SCC Online Delhi 121, Devendra Kumar Jain versus State. It was also a similar case where it was argued that the magistrate has jurisdiction to drop the proceedings at the stage of 251. The slight change in the terminology in the 1898 code and 1973 code was projected. In the 1898 code, the wording of 242, section 242 corresponding section was that the accused was required to show cause as to why he be not convicted. Now the present 251 says whether the accused has any defense to make. Basing on the change of phraseology between the two CRPCs, it was urgent before the Delhi High Court that under the new code, the magistrate is required to consider the defense of the accused to find out whether there is any offense is made out or not. Now, the Delhi High Court referred to the various provisions of CRPC and pointed out that there is in the case tribal sessions cases there is 227, and in warrant cases 239, private warrant cases 245, and so there is no provision in summons cases chapter 20 for dropping the proceedings or for discharge. So what is not there in the legislature cannot be considered. So that was the only judgment which is prior to this KM Matthew case. But in the KM Matthew case, the court held that it is implicit in section 251 that the court has got discretion, and there is no point in proceeding when the complaint allegations do not make out any offense. Now this judgment held field for quite a long time, and thereafter this Adalat Prasad case was decided by 3 judges. In fact, on an earlier occasion, in a judgment in a case titled Neelamani Rautre versus Bennett Coleman, also the correctness of this Matthew judgment was doubted, and the same was referred to a 3-judge bench. But since the said case was settled out of court, the reference was not answered. Thereafter, this Adalat Prasad case was taken up, and in this, the reasons set forth in KM Matthew case were highlighted in para 10. If we analyze the reasons given by the court in the said case of Matthew, then we notice that the said view is based on the following facts. The jurisdiction of the magistrate to issue process arises only if the complaint contains the allegations involving the commission of a crime. If the process is issued without there being an allegation in the complaint involving the accused in the commission of a crime, it is open to the summoned accused to approach the court issuing summons and convince the court that there is no such allegation in the complaint which requires his summoning. For so recalling the order of summons, no specific provision of law is required. These are the reasons which were called out. And the order of issuing process is an interim order. The learned judges in Adalat Prasad case pointed out that in none of these stages, the court has provided for hearing the summoned accused for obvious reasons, because this is only a preliminary stage, and the stage of hearing of the accused would only arise at a subsequent stage provided for in the later provisions in the court. It is true, as held by this court in Matthew's case, before issuance of summons, the magistrate should be satisfied that there is sufficient ground for proceeding with the complaint, but that satisfaction is to arrive at by the inquiry conducted by him, as contemplated under section 200 and 202. And the only stage of dismissal of the complaint arises under section 203, at which stage the accused has no role to play. Therefore, the question of the accused on receipt of summons approaching the court and making an application for dismissal of the complaint under section 203 for a reconsideration of the material available in record is impermissible, because by then section 203 is already over and the magistrate has proceeded further to section 204 stage. Then the lordships say that it is true that if a magistrate takes cognizance of offence, issues process without there being an allegation against the accused or any material implicating the accused or in contravention of 202, the order may be vitiated, but then the relief that an aggrieved person can obtain at that stage is not by invoking 203, because CRPC does not contemplate a review of an order. Hence, in the absence of any review power or inherent power with the subordinate criminal courts, the remedy lies in invoking 482 of the code. Therefore, in our opinion, the observation of the court in the case of Matthew, that for recalling an order of issue of process erroneously, no specific provision of law is required, would run counter to the scheme of the court, which has not provided for review and prohibits interference at interlocutory stages. Therefore, we are of the opinion that the view of this court in Matthew's case, that no specific provision is required for recalling an erroneous order amounting to one without jurisdiction, does not lay down the correct law. Sir, now we can think of any number of reasons in support of this reasoning, because it is now settled that the criminal court does not have any inherent powers, and when corresponding provisions for discharge are there in the trial relating to warrant cases and sessions cases, the very absence of such a provision in the summons case trial procedure shows that legislature never intended that this provision should be available to a person accused of a summons case triable offense. Now, the division of cases into summons case, warrant case, and sessions trials is based on the nature and measure of punishment. And in some summary trial cases, we don't even write a judgment. We only record in a register pleaded guilty, found guilty, convicted, and sentenced to pay a fine. So in some other summons cases, we undertake a trial just as a normal criminal case. But in a warrant case and sessions case, the process of framing charge and considering the application for discharge, all these are contemplated. But in this Adalat, that is the reason I personally feel that the purport of Adalat Prasad case needs to be upheld, though the facts of that case did not warrant any reference to the procedure under summons case. Now, after this Adalat Prasad case, immediately within a fortnight thereafter, Adalat Prasad case was decided on 25th August 2004, and on 17th September 2004, another 3-judge bench in Subramaniam Sethuram versus State of Maharashtra considered the same issue. This is a case for an offence under section 138 NI Act. The contention was that the statutory notice was defective. In this case, the learned magistrate had initially rejected the prayer for dropping the proceedings. Again, based on KM Matthew case, the petition has been allowed. The Sessions Court has set aside that order, and a criminal writ petition has been filed, and that is also rejected on the ground that once a plea is recorded, evidence ought to be taken, and then as against which an SLP has been filed and withdrawn, and all this procedure has been taken up by the company. Subsequently, having withdrawn the SLP within 10 days thereafter, one of the directors of the company files a similar petition on the same ground of defective notice. There also the magistrate allows the petition, and the complainant approached the Sessions Court, High Court, and the High Court allowed the revision on the ground that once the plea is recorded, it is not open to consider discharge. Then an appeal has been preferred before the Supreme Court. There was a reference to Adalat Prasad case, and at that point of time, it was urged that Adalat Prasad case concerned a warrant case, and the law laid down therein may not be good law. But the learned judges said that though it is true that Adalat Prasad case referred to 420 IPC, and Subramaniam Seturaman case concerns an offence under 138, the view of the Adalat Prasad case that there is no question of dropping the proceedings, recall of the order, recall of the summoning order in a summons case is not permissible. This thereafter, so the entire proceedings ought to have been decided in accordance with Adalat Prasad and Subramaniam Seturaman case. However, subsequently, one would having seen the spate of judgments of Delhi High Court, one would assume that the High Court of Delhi had taken a different path of differentiating Adalat Prasad case. But I came across two judgments of Kerala High Court, one of which is by Justice R. Basan. It is reported in 2005, 3 KLT 617, titled Kamala Rajaram versus DYSP, Office of SP Rural. It's a case under 304A, medical negligence. The accused had taken a plea that the ratio in Dr. Suresh Gupta case was not followed, and the complaint could not have been taken on file. There, the learned judge observes this. Whatever observation was made in KM Matthew case, Section 251 presupposes that the magistrate must consider whether such allegations are raised which amount to an offence. If no offence is made out, then there are no particulars of offence which have to be read over to the accused, and therefore proceedings cannot go beyond Section 251. This appears to be implied from Section 251 CRPC. At any rate, this case is covered by Section 258 CRPC because it's a case based on police report. Therefore, Section 258 could have been applied. The learned judge in para 6 of the judgment has by oversight written that notwithstanding Adalat Prasad, the learned magistrate, at least in a prosecution in a summons case instituted otherwise than on a police report, proceedings can be discontinued under Section 258. So in para 6, it is by oversight it is written that in a summons case instituted otherwise than on a police report, proceedings can be terminated. But in the final para, it is stated that this leaves the larger question whether 251 would justify discontinuance of proceedings in all summons cases, whether instituted on police report or otherwise need not be considered in this case. Suffice to say that in a summons case otherwise than upon a complaint, further proceedings can be discontinued under 251. Basing on that oversight, a case has been argued before the same learned judge in 2005 3 KLT, no, in Hassan MM versus Arun Kumar, that even in a summons case, it's a case under 500 IPC, the proceedings can be terminated under 258. But the learned judge has observed that it is a oversight, it is an erroneous this thing, and that the dictum ratio is that 258 can be applied only in a case instituted on a police report. The said judgment of Justice Basant has been later in 2010 ILR 2010 3 Kerala 145. Lordship Justice V. Ram Kumar in Anandavel versus Food Inspector has held that termination of proceedings at the threshold after appearance of accused permissible before the commencement of trial in a sessions case. In both these cases, it is held that the proceedings can be terminated before the plea of the accused is recorded. But once the plea is recorded, it must reach the logical end. Now, after this 2005 and 2010, we have a judgment of Delhi High Court in SK Bhalla versus State and others in 2011, DLD 219. There also they have they have opined that if the charge sheet complaint does not make out a triable offence, how can a magistrate state the particulars of non-existing offence? Yes. Section 251 deals with the state's subsequent issue of process under Section 204. The section casts a duty upon the magistrate to state to the accused person the particulars of offence allegedly committed by him and ask him whether he pleads guilty. This can be done by the magistrate only if the charge sheet, complaint, preliminary evidence recorded during inquiry disclose commission of a punishable offence. If the charge sheet, complaint does not make out a triable offence, how can a magistrate state the particulars of non-existing offence for which the accused is to be tried? Therefore, it is inherent in Section 251 that when an accused appears before the trial court pursuant to summons issued under 204 in a summons trial case, it is bounden duty of the trial court to carefully go through the allegations. Please mark this sentence, sir. It is bounden duty of the trial court to carefully go through the allegations made in the charge sheet, complaint, and consider the evidence to come to a conclusion whether or not commission of any offence is disclosed. And if the answer is in the affirmative, the magistrate shall explain the substance of the accusation to the accused and ask him whether he pleads guilty. Otherwise, he is bound to discharge the accused. This last sentence, that if the answer is in the affirmative, the magistrate shall explain the substance of the accusation to the accused and ask him whether he pleads guilty. Otherwise, he is bound to discharge the accused, have been verbatim taken over and placed in the judgment of the Supreme Court in Bhushan Kumar and another versus State NCT Delhi, another. AR 2012, Supreme Court 1747. Sir, Shyam, sir, it is there just above the Balla case. Sir, this Bhushan Kumar case is also a case under Section 420 IPC, which is also an FIR was registered by the concerned police. So there was no need for any reference to 251 in this case also.
Yes.
The Delhi High Court had held that the accused had challenged the cognizance order on the ground that it was a non-speaking order and reasons were not given. Now Delhi High Court held that there was no reason to give detailed reasons. There was no need to give detailed reasons at every stage, and as against which this appeal has been referred before the Supreme Court. The Supreme Court has considered Kanti Badra Shah and Roshanlal Agarwal, UP Collusion Control Board, etc. decisions, where it is held that there is no need to give reasons. Thereafter, in para 17, whatever has been read out from S.K. Balla case, that has been incorporated. He has to come to a conclusion. Sir, yes, sir, para 17. It is inherent in section 251 of the code that when an accused appears before the trial court pursuant to summons issued under 204, the code in a summons trial case, it is the bounden duty of the trial court to carefully go through the allegations made in the charge sheet of complaint and consider the evidence to come to a conclusion whether or not commission of any offence is disclosed. And if the answer is in the affirmative, the magistrate shall explain the substance of the accusation to the accused and ask him whether he pleads guilty. Otherwise, he is bound to discharge the accused under the first line says 251. The last line says 239. They are located in different chapters. But based on this judgment, there are several other judgments subsequent to 2012, where it is in all summons, even in summons cases, it is said that this, notwithstanding the dictum in the Adalat Prasad case, the order of the magistrate can drop the proceedings if the complaint does not make out any offence. Sir, in the later case, this Delhi High Court in Arvind Kejriwal versus Amit Sibal, sir, if the magistrate cannot discharge, this is also here also it is held that if the magistrate cannot discharge the accused at the stage of framing notice, the whole proceedings at the stage of framing of notice will be reduced to a mere formality, and the accused would be compelled to approach the High Court to challenge the notice, which would lead to multiplicity of litigation. It is for this reason the Supreme Court in Bhushan Kumar and Krishan Kumar Warrior has observed that the accused should approach the trial court instead of rushing to the High Court. In this Krishan Kumar Warrior, sir, there was an objection regarding territorial jurisdiction of the court regarding the place of issuance of check, etc. There it was observed that the petitioner could have as well approached the trial court. Basing on the judgment of Bhushan Kumar and Krishan Kumar Warrior, it is observed that the accused should have, the Supreme Court has not restricted the directions to case in the aforesaid two cases to be applicable only to the warrant cases, and therefore the same are applicable to all summons cases, including those arising out of complaints. In Bhushan Kumar, the Supreme Court has specifically referred to section 251, which deals only with summons cases, relying on the aforesaid judgment. This court in Rajiv Taneja, Urshila Kerkar has directed the accused to urge his objections before the trial court at the stage of framing of notice under section 251 CRPC. This court is in complete agreement with the view taken by this court in Rajiv Taneja, Urshila Kerkar, and S.K. Valla that at the stage of framing of notice under 251, the learned magistrate is not expected to mechanically frame notice and has to apply its mind to find out whether the prima facie case is made out or not. The learned magistrate has to frame the notice under 251 only upon satisfaction that a prima facie case is made out. However, in the event of finding that no case is made out against the accused, the learned magistrate would be well within his right to drop the proceedings against the accused. This court also agrees with the view taken by Sunil Gaur Justice in Rajiv Taneja and Urshila Kerkar that the judgment of the Supreme Court in Adalat Prasad would not stand in the way of the trial court to do so, because the discharge of an accused at the stage of framing of notice under 251 does not amount to recall review of summoning order. Thus, two stages are different. The first is the stage of issuance of process, when the magistrate has to satisfy that there are sufficient grounds for proceeding the matter. The second is the stage of framing of charge notice, when the court has to be satisfied that the prima facie case is made out against the accused. However, since section 258 does not empower the magistrate to discharge the accused in summons cases instituted upon complaints, this court considers it necessary to issue directions in this regard in exercise of inherent powers under 482, read with 483 and 227 of the Constitution. The provisions contained in CRPC are not exhaustive. In administering justice as prescribed by the Code of Criminal Procedure, there are necessarily two shortcomings. First, there are cases and circumstances which are not covered by the express provisions of the code where justice has to be done. The reason is that the legislature can foresee only the most natural and ordinary events, and no rules can regulate for all time to come, so as to make express provision against all inconveniences, which are infinite in number, so that their dispositions shall express all the cases that may possibly happen. Second, the prescribed rules of procedure may be abused or so used as to give a mere formality the significance of substantive effect and thus obstruct instead of facilitating the administration of justice, as in the present case. Sir, as against this judgment, the appeal was referred to Supreme Court in Amit Sibal versus Arvind Kejriwal. In this case, somehow the counsel for the opposite party has not chosen to contest, has not chosen to advance any arguments. This is what is written in the short order. The appellant has challenged the aforesaid directions in these proceedings on the ground that in a complaint case where summoning order has been issued and no charge is to be framed, and the order permitting the respondents to raise such contentions at the stage of framing of notice and directing the magistrate to consider the same and cause of property is contrary to law. The substance in this contention raised by the learned counsel for the appellant to this legal position is not even rebutted by the respondents. So the Supreme Court had an occasion in this case to consider the correctness of the observations in Bhushan Kumar and to set things right. But on the basis of, on the ground that the counsel did not resist the arguments, did not rebut the arguments, the case has been simply remitted to the Delhi High Court. So this judgment, which could have clarified the position, we did not take up the task. Now, finally, in regard to expeditious trial of cases under section 138, this question has been elaborately dealt with. In KM Matthew versus State of Kerala and another, the court dealt with the power of the magistrate in chapter 20 of the code after the accused enters appearance in response to the summons issued under 204. It was held that the accused can plead before the magistrate that the process against him ought not to have been issued, and the magistrate may drop the proceedings if he is satisfied on reconsideration of the complaint that there is no offense for which the accused could be tried. This court was of the opinion that there is no requirement of a specific provision to drop the proceedings, and as the order issuing process is an interim order and not a judgment, it can be varied or cancelled. The observation in the case of KM Matthew that no specific provision of law is held to be required for recalling an erroneous order of issue of process was held to be contrary to the scheme of the code in Adalat Prasad. Thereafter, in para 20, sir, para 20. The amicus curiae appears to have advanced an argument that in meters and instruments case, a provision it has been observed that proceedings can be dropped even in the summons case. Section 143 mandates that the provisions of summary trial shall apply as far as may be to trials of complaints under 138. Section 258 empowers the magistrate to stop the proceedings at any stage for reasons to be recorded in writing and pronounce a judgment of acquittal in any summons case instituted otherwise than upon a complaint. Section 258 is not applicable to a summons case instituted on a complaint. Therefore, 258 cannot come into play in respect of the complaints filed under 138 of the Act. Judgment of this court in meters and instruments, insofar as it conferred power on the trial court to discharge an accused, is not good law. Support taken from the words as far as may be in 143 is inappropriate. The words as far as may be in 143 are used only in respect of applicability of 262 to 265 of the code and summary procedure to be followed for trials under chapter 18. Conferring power on the court by reading certain words into provisions is impermissible. A judge must not rewrite a statute, neither to enlarge nor to contract. Whatever temptations the statesmanship of policy making might wisely suggest, construction must eschew interpolation and evisceration. He must not read in by way of creation. the judge's duty is to interpret and apply the law, not to change it to meet the judge's idea of what justice requires. The court cannot add words to a statute or read words into it which are not there. 21. A close scrutiny of the judgments of this court in Adalat, Prasad and Subramaniam Seturaman would show that they do not warrant any reconsideration. The trial court cannot be conferred with inherent power either to review or recall the order of issuance of process. Sir, having said all this, yet the question remains whether as interpreted by Justice Basant and Justice Ramkumar, whether at this stage of 251, before a plea is recorded, when no offense is made out in the complaint or the source statement of complainant, whether the court can proceed further when the particulars do not make out any offense, whether the court can proceed further. This aspect has not been dealt with by any court. As far as I am concerned, my opinion is even in warrant cases or sessions cases, very few courts have allowed discharge petitions. So undertaking a discharge petition or any petition akin to discharge petition in summons cases will only add to the already burdened trial courts, because ultimately either way the order goes, the matter will be taken to the High Court. So we can only we need only sensitize the judicial officers to ensure that when taking cognizance, due attention be given to the contents of the complaint or the statement, so that such a scope is not given to raise any objections. Even in a discharge petition, only the material placed by the prosecution will be considered. The material placed by the defense is not likely to be considered, at least in the trial courts. So, without giving scope for protracting the proceedings, if the provision of law as it exists is enforced, that would meet the ends of justice. If at all the legislature intended to give any space for consideration before proceeding further, similar provisions as is found in 227, 239 and 245 would have been there. Even now, in the judgment regarding this 138 cases, the learned judges have said that however amendment to the act empowering the trial court to reconsider recall summons may be considered on the recommendation of the committee constituted by this court, which will look into this aspect as well. So whenever any such amendment is brought in, then we can attempt that. Otherwise, it is better to proceed with the examination of the accused with whatever offense that has been taken on file at the stage of taking cognizance. And if it is a police report, we can have recourse to 258. If it is a complaint, we have to necessarily go through the remaining procedure. Thank you, sir.
Thank you very much, Virupaksha, sir. Let us have the comments of Justice Ramkumar, sir, and others before we open up. Ramkumar, sir.
Thank you, Mr. Shyam. Excellent articulation. You have conducted an extensive research. In fact, I have not seen many of the judgments quoted by you. That 2018 judgment I have not seen, to confess frankly. Now, three things I would like to add. Justice S. Padman was of the Kerala High Court, probably was the first judge who said that in a summons case on a private complaint, after the substance of accusation has been read over to the accused and his plea is taken, trial starts. Trial starts when the substance of accusation is read over to him and his plea is taken. Once trial has started, the case can end only in either an acquittal or conviction. There is no via media termination of the case. That view was overturned by the Supreme Court in K.M. Matthews case. Adalat was, mind you, throughout the length and breadth of the country, magistrates used to terminate proceedings straight away on the plea of the accused after his appearance on summons, following KM Matthew. 12 years had to elapse for KM Matthew to be overruled. Now, what we have understood is that the after Adalat Prasad, followed by other rulings, the trial in a summons case starts only with the reading of the particulars of the offense to the accused and taking his plea. But even before that, if the court finds that the materials produced in the complaint, there's absolutely no material, no allegation, or even especially the ingredients of the offense are absent in the complaint, why subject him to the trauma of a trial by reading out the substance of accusation to him? So even before the trial can commence, why not drop the proceedings in the interest of justice? That weighed with me and probably with Justice Prasad also. That was, of course, a summons case, police charge case. My case, it was a private complaint, summons case. That I would say that it was Justice Padman from the Kerala High Court who ruled for the first time that in summons trial, there cannot be a via media termination of the case after the commencement of trial. Now, but what about 197 sanction? Now, courts have taken the view that the question of validity of sanction or want of prosecution sanction can be raised at any stage. If it can be raised at any stage, is it not permissible for the accused after receipt of summons to tell the magistrate, look, magistrate, you have taken cognizance without a prosecution sanction. I am a public servant. You should have insisted on a prosecution sanction. So is it not permissible for him to raise it at that stage? Of course, there is one decision where the Supreme Court said that at the 204 stage, he cannot, one solitary decision, he cannot raise it and he will have to go to the High Court under 482. Anyway, leaving it aside. Then thirdly, even after taking cognizance of the offense and without dismissing the complaint under section 203, is it not open to the magistrate to refuse to issue summons under section 204 CRPC, stating that there is no sufficient ground for proceeding further? 203 he did not dismiss. At the threshold, he did not reject the complaint. Then 203 he did not, even after cognizance, he did not dismiss the complaint. Then come 204. Can he not say, according to me, I am only thinking aloud for the erudite members to articulate. Can he not say under section 204 that I don't find sufficient ground for proceeding further, so I am not issuing process, and drop the proceedings? And it may not be proper to say that in a summons case there is a discharge, as you rightly said. There is no discharge in a summons case. It's only in a warrant trial or session trial case. Because once there is a charge, there can be a discharge. And there is no charge to be framed, there cannot be any discharge. Of course, the word discharge can be understood as dropping the proceedings. These are all my observations. Thank you. Wonderful articulation.
Thank you, Ramkumar sir. Before we come to Justice Ramana sir, may I request Nagamatu sir.
Brother, could you hear me?
Yeah.
Oh yes,
yes.
Oh yes.
Yes,
We can see you also.
Yes. Good evening to all of you. So, at the outset, I should thank our friend Mr. Gouda for having done a wonderful research and placed all the relevant judgment before us for our consideration. So, I once again thank him for that. And as far as my views are concerned, they are all in concern of the views expressed by erudite brother, Honorable Justice Ramkumar. See, so far as the Adalat Prasad and Subramaniam
Swami.
Setharaman case are concerned, they are right in a way. What they say is that after the complaint is entertained, when there is no order of dismissal under 203, there is no provision to drop the proceedings. So they are right. Now, Mr. Gouda was referring to some of the judgments where, and he was also articulating on the question of discharge in a summons case. So what I would say is there are two different stages. Under section 190, cognizance is taken at that time, accused is not heard. Now, can we say that after cognizance is taken, ex parte, the accused should be given right to come and tell the court, you have taken cognizance without my presence and without hearing me. There is no material to take cognizance. Please drop the case. You please recall that order. Can you ask that? No, it's not possible. So that stage goes. Then thereafter, what happens? Then he refuses to dismiss the complaint in 203. So therefore, applying the same logic, I would say that at that stage also, we cannot go to the court and say, request the court to dismiss the complaint at this stage. So the next stage is issuance of summons under 204. And Honorable Justice Ramkumar was saying that we can think of one thing. That is, at that stage, we can't be request the court not to issue summons under 204 to the accused by giving an opportunity to the accused. For the opportunity to the accused arises only after issuance of summons, then only he appears. So 204 stage is also crossed by the time when he appears. So
You're
therefore, it's also not possible. That's what I feel. The magistrate cannot refuse to issue summons to the accused because it is only a follow-up action. Accused appears only after service of summons under 204 issuance and service. So at that stage also he cannot do. Then comes 207 or 208, they come. At that stage also it is not possible. Now the next stage for the accused to ask for relieving him from the case is discharge stage. So legislature in its wisdom has thought it fit to make a provision for discharge only in sessions cases and in foreign cases. There is no provision made consciously because it is a small case where we should not allow the court to consume so much of time. Therefore, they did not make any provision. When the legislature has consciously omitted to make a provision for discharge in a summons case, then we cannot create one provision and supply the same into the court. That is not possible. So what is the way out? It doesn't mean that the accused has got no remedy. So all of us will agree that accused has got remedy and therefore it to go to the High Court. So at all stages, he can challenge the order under 190, he can challenge the order under 203, he can challenge the order under summoning order under 204, he can challenge the order refusing to discharge also. So all these are available now up to 251 stage. So all these things are available for him, for the accused. So in a summons case, when the legislature has thought that we need not make a provision for discharge, we cannot make a provision to enable a magistrate. This is my humble way. Please.
Excellent, wonderful.
Thank you, sir. That is
Now, pausing here,
discussion.
without interruption. 204, I was not arguing, I was not making a submission that accused can argue. No.
Okay.
Supposing the magistrate has not dismissed under 203, and supposing at a later stage, magistrate before issuing summons discovers that there is no ground for proceeding further, is it not permissible for the magistrate without being aided by the accused, without being addressed by the...
I understand the question. So at that stage, consideration is who is the accused. Under 204, it is only identifying the accused.
Yes.
At that stage, he is not concerned with the offense. So whether any offense has been committed or not is dealt with under 190, then under 203. There ends the matter. So at 204 stage, what he does, the limited work that he does is to identify the accused to whom summons is to be issued. That's all he does. So he cannot go back and verify the records and to say that no, I have committed a mistake and there was no sanction order. Therefore, I am not willing to issue summons. That I don't think that will be possible. And even this is done in the present day context, I don't think that the Supreme Court will approve this.
I would draw a parallel. See, supposing information regarding the commission of a cognizable offense is made to an officer in charge of a police station, he is bound to register a crime. Now, after Lalitha Kumari, certainly. But Lalitha Kumari also recognized a power of the investigating officer that even if he is bound to register a crime under 154, he is not bound to enter on investigation.
Yes.
So I am drawing that parallel here.
Thank you, sir.
It is for the erudite members to articulate on that.
Now, may I request
Mr.
Justice
Gouda, thank you, Mr. Gouda, for the wonderful lecture.
Ramana, sir, over to you.
Thank you, Mr. Gouda, for the research you have undertaken and enlightening us on the subject. I'm also thankful to Justice Ramkumar and Justice Nagmuthu for their wonderful analysis. But one question that bothers me always is, what is meant by discharge? And what is the effect of discharge? Ultimately, what is the effect of discharge?
Not acquittal. There can be another process.
Not an acquittal, but
Such a thing is
ultimate,
not applicable.
yes. Then why do the accused go for applications under 239 or in Sessions case under 2? I don't recollect the provision.
27.
227.
227, right. For discharge, many times, particularly in Prevention of Corruption Act cases, they go for this type of applications. They know the consequences of an order, even if they get an order of discharge. At a later stage, the court is entitled, I don't say prosecution has got right, but court is entitled to recall that order and ask them to face the music of prosecution.
Court cannot recall.
No, after discharge, no.
Court
That's
cannot recall.
that's
After
exactly
discharge,
what.
court cannot recall. There can be another proceeding afresh, upon which once again cognizance is to be taken. The very same procedure is to be followed.
Okay, sir, I agree with you.
He cannot start from where he lastly he left the
All
case.
right.
He has
So
to
ultimately,
move on.
see, so far as that prosecution is concerned, the accused need not face further proceedings. Okay, once discharge order is passed.
Yes.
Out he goes. Out
Sir?
he
Yes.
goes with the
Exactly.
discharge.
Exactly. I don't think the legislature has forgotten to incorporate a provision relating to discharge for the purpose of summons trials.
No, what we understand is legislature has not forgotten. Legislature kept it in mind and consciously omitted to make a provision.
All right, I borrow your words, sir. Consciously omitted. Fine, I agree. Is it permissible for us to take the situation likewise? Was it a conscious? Is it a conscious omission by the legislature?
Yes,
don't-
it is.
I
It
don't.
is.
No, I don't.
Why we support UP is
Yes.
legislature has made a very specific provision in section 227 in respect of certain cases.
Yes.
In respect of warrant cases, both in the private complaint as well as police report case, there are provisions like 239.
Right.
When the legislature has made 3 specific provisions for discharge,
Okay.
why the legislature has not made such a provision so far as summons case is concerned?
Yes.
Therefore, we say that it is a conscious omission.
Right, sir. I agree with you, sir. But what is the effect of section 258 CRPC?
Only police charges.
No. What is the effect, sir? Ultimately,
Not
what
in
is
a
the
private
effect?
complaint.
No, I agree with you. The situation when we can apply 258 is something different. Okay.
Release.
It's not release, but with the stoppage of proceedings.
Or release. Stoppage or release. Yes.
All right. Well, release the accused, and such release shall have the effect of discharge. That's what the last words of section 258 say. You meant to say that section 258 did not contemplate a situation where a party can approach the court, an accused can approach the court for discharge. See, there are two situations contemplated in terms of 258. Suppose trial goes on. Upon examining the accused with reference to substantive accusations against him under section 251 CRPC, and principal witnesses are examined. Then is it not open for the court to apply section 258? Certainly, court feels that there is situation which calls for such remedy. Okay, it can apply, and the nature of order passed under section 258 is of an acquittal. That's what section 258 says. Second situation is where evidence is not recorded and accused has appeared before the court. And court finds ultimately that there is no material to continue prosecution. Okay. Then it is within the power and province of the court to direct stoppage of proceedings and such a direction that such relief given by the court will have the effect of discharge. These are two situations contemplated by Section 258 CRPC. So in this backdrop, or when we have this scenario before us, can we say that the summons cases, the accused has no right to seek discharge, or request the court to pass an order in terms of Section 258, stopping the proceedings at two different stages, and which order will have the effect of discharge? And whatever rulings Mr. Gouda has cited, in fact, he happens to be my good friend, Gouda has cited, did not consider the scenario. Probably in one case which Mr. Gouda was referring, there was, what he was saying is, he was commenting was, it was a inadvertent reference, Section 258, and unconsciously made by one of the land judges, probably of Karnataka High Court.
No, Justice Basan that referred to 258.
Kerala High Court, some judgment
Yes.
is referring to.
It was a private complaint, police charges. I'm
No,
sorry. It was a summons case, police charge case.
Sir, Ramkor sir, please bear with me. I'm not referring to cases, filed cases on complaint. Okay. I am referring to cases which are continuing basing on the police reports. I am considering cases based on police reports.
Okay.
Because 258, I think
Applies only to.
I did not say that it applies only to police cases. Then is it not open for an accused? I don't want to go into any case law. Just casual reading of this provision definitely gives an indication that there is possibility for an accused to invoke this provision when there is no material at all against him. Okay. And is it not open for him to seek that, say, I should not unnecessarily face this prosecution when it is completely baseless and without any substance? No, I'm just giving out my idea for simple reason that many people in this country cannot afford to approach High Court in terms under Section 482 CRPC. Okay. We all agree that many accused are poverty ridden. How many of them can afford to approach High Courts? .482 exercise will not be a very, very simple matter. We know what happens in 482 in High Courts. Once an application is filed, how long it takes for the disposal. Of course, these are all inherent problems which we face in a system. Okay. Ultimately, the system is answerable for all these things. But when there is a provision which gives a definite indication that it can be applied when it's called for, when its application is called for, then why not an accused file an application in terms of Section 258 to stop proceedings? That's why I wanted to know the result of what we mean by discharge. What are the consequences of discharge? The first and foremost question was, what is the effect of and what are the consequences of discharge?
Sir, may I respond to this?
Yes, sir. I want clarification on this from you.
So we were talking only about 251 so far, as you rightly pointed out. So far, 258 is concerned, there is a state judgment in support of the view that you have expressed. That 6 ACC page 30. I think that this was referred to by somebody here. John Thomas versus Dr. K. Jagadish. Whether this was cited?
No.
No. No?
Not cited.
Okay. You please see, I have right now before me So it actually supports the view which has been expressed by our friend. This was a case instituted on a private complaint. Ultimately, the High Court said, Supreme Court said that because it is a private complaint procedure, Section 258 is not applicable. But the Supreme Court has said in paragraph 8 like this, may read that.
Yes, sir. Yes, sir. Yes, sir. Very kind of you.
Categories. Those instituted upon complaints and those instituted otherwise than upon complaints. The latter category would include cases based on police reports. Section 258 of the code is intended to cover those cases belonging to one category alone, that is, summons cases instituted otherwise than upon complaints. The segment separated the last part of the section by the subcategory is not intended to cover all summons cases other than those instituted on. In fact, Section 258 sets only summons cases instituted otherwise than on complaints into two divisions. One division consists of cases in which no evidence of a material witness was recorded. The section permits the court to acquit the accused prematurely only in those summons cases instituted otherwise than on complaint, wherein the evidence of material witnesses was recorded. But the power of the court to discharge an accused at midway stage is restricted to the cases instituted otherwise than on complaint, wherein no material witness was examined at all. So, we supported here.
What is the citation, sir?
2001 to 2001 60 SCC, page 30, Justice Thomas.
30.
Yes, two judge bench. Actually, so therefore, as he points out, it is not everyone can afford to come to the Supreme Court, High Court or the Supreme Court. We should find out some way to give them immediate relief.
The solution lies with the legislature.
Yes. Instead of filing an application for discharge straight away for want of provision, and in order to overlook or overcome the Adalat Prasad and the Subramaniam case, I feel that we can advise the parties to make application under Section 258. If evidence has already been recorded, as Justice Ramkumar was pointing out, if it is a case where sanction is required, there is no sanction at any stage. Some witnesses have already been examined. So at that stage, he can make an application for acquittal, right? By stopping it is not directly an acquittal, it will have the effect of acquittal. And similarly, in a case where no witness has been so far examined, the accused can ask for stoppage. Even the proceeding is stopped at that stage, it will have the effect of discharge. So 258, I'm grateful to our friend for having brought to a notice his appropriate provision. And
No, sir, really, I'm thankful to you for your wonderful analysis, and giving us this citation, because I did not go through it, and just I was in the afternoon. I say, of course, to share with you, I had discussion with Mr. Gouda.
Yes.
But I wanted to know what exactly topic you wanted to discuss.
It was not extensively dealt with by us. 258 is the appropriate provision, which gives some solace for the parties.
But somehow this practice is not going on in many courts. No application is being filed in terms of Section 258 in summons cases.
But we have to work out on this and what are the parameters upon which a court can stop the proceedings.
Yes.
It is the same standard.
Even in 2018 case that is relating to NIT cases also, I think there is no reference to, I think there is reference to 258, but they did not consider, say, with a reference to cases instituted otherwise than on complaint. Isn't so, Mr. Gouda? Yes. In NIT cases, where the actions were given. But in cases instituted upon complaint, I think I must necessarily agree with Justice Ramkumar. And accused can come up with an application in terms of Section 203 CRPC, read with Section 204 CRPC, questioning the variations of summons. Because the power in such cases, the power to dismiss a complaint is drawn by the court in terms of Section 203 CRPC. This is at initial stage, at the threshold.
At that stage, accused has no right to.
All right, I
Right,
agree with
yes.
that. That's exactly why I'm referring to. Let him file an application in terms of section 204, let me section 203.
So what is his locus standi to address the court?
No. That's the reason why I am just I want the accused to invoke section 204. See, pursuant to issuance of summons in terms of 204, he appears before the court. Absolutely no doubt about this.
Pursuant to 204.
Yes.
There, of course.
Yes, of course. Then at the stage, can he not request the court or call upon the court to invoke its power under section 203? Because there is only one provision which provides for dismissal of the complaint at threshold. That is only under section 203.
Then courts are unanimous in saying that the criminal court cannot go beyond the stage, cannot go back to a previous stage.
That is, there's no power to review. Okay.
Not only review, no inherent power to go back to the previous stage, unlike a civil court.
Hmm.
How to get over that?
No, that's exactly why.
You have a point in doing justice to the parties, but then after 204, that is precisely what Adal Prasad said. Once you cross 203 and come to 204, you cannot go back to 203.
Sir, then one
Enough, we are confused by various judgments. I am also very incidentally, I will bring it to your notice yet another judgment. We
Yes.
kindly see what is stated in paragraph 14 of this judgment. This is 2009 judgment. So
Citation, please.
enough to confuse it. I thought that we have found out some solution. See, 2009 14 SEC 345. Again, with two judges.
Yes.
Paragraph 14.
What is page number, sir? Page number, sir?
214. Sorry,
2009, 14 SEC 345.
345. So this is the police report case. See paragraph 4 of the order. Accused absent. It is noted that the accused vacated her address and her whereabouts are not known. Offensive is probable a summons case. Hence, further proceedings stopped under section 258 CRP. This was the order passed. Right? Now, what the Supreme Court says, it is very curious. An order of discharge can be passed in terms of section, paragraph 13. The proceedings are stopped by the London Magistrate in terms of order dated 14/10/2004, right? Which was what I read. No consequential order was passed, and indeed could not have been passed. The benefit of effect of discharge could have been claimed by the appellant had she been directed to be released. The effect of discharge being correlated with the release. If she had not been released, the question of her obtaining the benefit of the effect of discharge does not arise. Could you understand anything out of this?
Are they referring to section 300 clause 5?
No. See, magistrate stoppage. Stopped the past stoppage order under 258.
Yes.
But she was not released. The accused was not released. They said that there has to be a consequential order releasing. I do not know what is the consequential. Where is it? Once there is an order of stoppage, then it will have the effect of discharge. It will have automatically by operation of law, it will have the effect of discharge. But what they say that there has to be some consequential order passed. I do not know. I will read it again for a benefit of all our friends. The proceedings are stopped by London Magistrate in terms of order dated 14/10/2004. No consequential order was passed. And indeed could not have been passed. What is this? What is the consequential order which that could be passed with? Then he says, the benefit of effect of discharge could have been claimed by the appellant. Appellant could have claimed it had she been directed to be released.
Those are two alternatives, is it not? 258.
No, sir. Let's go back to the fact. I think the circumstances under which the complaint came to be passed, the police case was dismissed. I think just Nagbut was referring to certain facts.
No. No witness was examined.
Okay.
Proceedings pending. Summons was issued to the complainant. Complaint whereabout not known. That is the information. Whereabout not known.
Okay.
Therefore, the court passed an order of discharge. Right?
Okay.
After that, see, the Supreme Court says, policeman, see, if I read paragraph 14, it will make things very clear. Paragraph 14. An order of discharge can be passed in terms of section 245 of the code. For passing an order under the aforesaid provision, reasons are required to be recorded. Right? The in the present case did not record any reason. What is the reason? He has already recorded that there is the whereabouts are not known. Mandatorily, reasons were recorded to be recorded. The reasons were required to be recorded. The London Magistrate, thus, although he has power to revive the proceedings, he should have passed an appropriate order upon application of mine. He did not so. He directed reopening of the case and a direct issuance of non-bailable warrants of arrest again without recording any reason. It appears from the order sheet dated so and so that some reasons have been stated in the requisition made by the police, Bangalore, for issuance of non-bailable warrant, etc. For the reasons above mentioned, although the High Court is correct, the London Magistrate in a situation of this nature could have revived the proceedings. In our opinion, the London Magistrate committed an error in not recording.
Under section 305.
305. 300 clause 5. That is
Revival
referred to.
Revival is under section clause 5 of the section 300. That was not done, probably. I don't know.
That is referred to in this Renuka judgment.
No, let me read 305.
Yes.
A person discharged under section 258 shall not be tried again for the same offence except with the consent of the court by which you are discharged or of any other court to which the first mentioned court is subordinate. What is the consent? Where is the revival?
Because proceedings were stopped or released. Accused was released. So it can be revived only with the permission of the
Consent.
Consent. That's
usually
consent.
Consent is only permission.
No, discharge, see, please tell me, after the stoppage order, what is the consequence order that should be passed by the magistrate?
No consequential order.
Nothing.
Judgment says, otherwise it will have no effect of discharge. One. That is what I read in paragraph 13. Then it further proceeds to say that the police officer can make an application to the same court to revive the proceedings. Right? So while reviving, the magistrate has to record reasons. I don't know what reason can we record here. So this petition is made under section 305 according to you.
Yes, because if principal witness alone had been examined, then it is discharged.
No, sir. If principal witnesses have already been examined,
Principal witness alone has been examined, it is discharged. Otherwise, release.
No. In case any witness is examined, including principal witness, what section is principal witness?
That is the wording of 258.
258 says principal witness.
258 after
One
the
case.
examination.
For release. Sir, I'm sorry for discharge.
Sir, after examination, witness, it is only acquittal.
See, the wording is almost identical to section 321. 321 also withdrawal from prosecution. There also, principal witness has been examined, discharged. In all other cases, acquittal. Same, yes. Almost similarly worded.
No, see, you take the situation. Let us say the PW1 has already been examined, or 2-3 witnesses have been examined. At that stage, you have to stop the proceedings. It is acquittal. In such an event, 305 is not applicable. 305 is not applicable. It is applicable only in respect of discharge.
Yes, sir. You are right. Absolutely right.
Suppose before examination, any witness stoppage order is passed. Let us say there are 2 cases before us. In one case, after the witness have been examined, a person comes and accused tells the court that there is no sanction. He is acquitted. The other case, even
he can only be discharged. Sanction for want of prosecution.
After the examination of witnesses, if any order of stoppage is made, it is only acquitted. 258.
Even prosecution sanction, you mean?
Yes, whatever be the case. If it is stopped, someone's case, stoppage of proceeding, acquittal. If he is acquitted, 305 is not applicable.
If it is acquittal, then will it not bar a fresh trial?
That's what I say. So the accused has to wait. Let him come in, let him examine one witness at least. Thereafter, he has to make an application for stoppage. If he stopped at that stage, he will be acquitted. There is no revival.
Yes.
Suppose
that's it.
with over anxiety, he files an application even before examination of witnesses and gives the discharge, then it can be revived after rectifying the defect.
Yes.
And the 3 So clever way is to advise you don't make any application of wait.
Yes, yes.
Witnesses. Then you make it.
Part of advocacy. No, nothing wrong with it.
Yes.
Part of advocacy.
Yes. Good, sir.
Ultimately, you must safeguard the interests of the parties.
Sir, very good articulation.
Sir,
Thank you, sir. Thank you.
may I request Prem?
Well, after having Justice Ramkumar, Justice Ramana, and Justice Nagamuthu analyzing all this, there is nothing more which is left to analyze. Anyway, now as we know this, till this Adalat Prasad, see, Adalat Prasad, I would say it's a 3-judge bench. And kindly see the names of the judges, because I am naming the judges only because this bears high significance. Justice Santosh Hegde spoke for the bench with Justices S.B. Sinha and Justice A.K. Mathur. Now, recall of summons, as Shyam has put it, it was traceable to K.M. Matthew. And that was a particular practice which had held the field for over a decade. And para 8 of Matthew's case, that was the relevant para which held that it was open to the accused to plead before the magistrate that the process which is issued against him ought not to have been so issued, and the magistrate may drop. Now, please see, K.M. Matthew, Justice Santosh Hegde, he goes on to hold that there is no specific provision
Enabling the magistrate to drop.
For the magistrate to drop. And please see, here, one more thing I need to say, that Adalat Prasad does not interfere with one of the findings of K.M. Matthew. K.M. Matthew found that an order, a summoning order, is an interim order, not a judgment. So it cannot be varied or recalled. Adalat Prasad did not even touch it. Please see para 17, I think, of Adalat Prasad. Now let me come to the point. Subsequently, K.M. Matthew, as Mr. Gouda has put it, that was doubted in Neelamani Rautri 6 years later. And then it was referred to a larger bench, and that case was settled out of court. So nothing could happen. Finally, this comes in Adalat Prasad. Now, please see, if you closely read Adalat Prasad, Justice Hegde, he has left open the finding in Matthew. What? That the order of issue of process that amounts to an interim order. And in my humble opinion, the ratio, it is too hyper-technical, because it has been turning a Nelson's eye to the stark ground realities. And this judgment has to be forthwith reconsidered. Why? Now, to say once process is issued, and if the court drops the proceeding, it would be a review. I don't think so. It would be a review, because such a finding, in my humble view, it is not only irrational, but also illegal. Now, I would tell why. Now, if that be so, now the legislature itself, let us see, has provided options for discharge, as Justice Nagamuthu has put it, in warrant cases as well as in the sessions cases. So, it is after issuance of process, the accused seeks for discharge, right? Leave alone all the non-availability of a provision akin to discharge in a summons case. But did not the 3 judges bench sidestep and overlook this particular fact while deciding this issue by applying the procedure which is applicable for summons trial? And now see, as Mr. Gouda has put it, one of the most ridiculous facets. Now, Adalat Prasad, that dealt with offences under sections 120A, 120B, 420, 415, etc. of the IPC. And taking cognizance, the learned magistrate, after taking cognizance, he summoned the appellants and the other accused by issuing process. And the process, and the offences, it was confined, I think, to section 420 and 120B IPC. And if you go by the definition of section 2, W and X of CRPC, this was not a summons case. It was a warrant case because we are having a fine imprisonment of 7 years, which can exceed up to 7 years in 420. Now see, the relevant section of the CRPC, which has the heading, the court not to alter the judgment.
362.
That is 362. And what does 362 say? If you see 362, if you bisect 362, it reads like this. The court not to alter the judgment, save as otherwise provided by this court or by any other law for the time being in force, no court. Now kindly see, when it has signed its judgment or final order disposing of a case, shall alter or review. So if you bisect it, you can see once it has signed the judgment or the final order,
Disposing of the case.
disposing of the case. Now, can issue of process to an accused, can that be equated either with the judgment or a final order disposing of the case? I don't know, maybe in my humble opinion, I really fail to understand this. It cannot be 362 because if you see para 17 of Adalat Prasad,
No, you are right.
Just
That
consists-
is left open.
yes, because where Adalat Prasad goes on to say that it was not necessary for them to go on and decide whether it was an interim order or not. Why? See, if that question itself is left open, how are you going to take that the order of issuance of process from within the ambit of section 362 CRPC? If that question is left open. Now, this question looms large on reading para 17. And subsequently comes another three-judge bench decision, that is Subramaniam Seturaman. Again, kindly see the judges. Justice Santosh Hegde with Justice Sinha, and the only change was instead of Justice Mathur, now comes Justice Tarun Chatterjee, who are seized with the matter. Now you understand why I refer to the names first. Now kindly see, in Subramaniam Seturaman, what happens? Attention of the three-judge bench is drawn to its decision in Adalat Prasad, saying that, see, kindly see that this is a warrant procedure case, which is reflected in paras 10 and 11 of the judgment. And the senior counsel who argued, he sought to reconsider Adalat Prasad, arguing that Adalat Prasad, in fact, it proceeded on the basis that it was a summons case, but in reality, it was a warrant case which was covered by Chapter 19. And of course, the respondent's counsel also, he also highlighted that fact. Bearing in mind all this prohibition under section 362. Now, if we read paras 4 and 16 of Subramaniam Seturaman, we get a different idea. Now, Subramaniam Seturaman was a case under section 138 of the NI Act, where, as Mr. Gouda has put it, first, it was a case against the company and the directors. On receipt of the complaint, the company challenges the same before the very same magistrate, saying that, see, he could not have taken cognizance of the offense. Why? Because of a defective statutory notice. And the company seeks for a discharge. This application was rejected. Then comes the second application, which was allowed by the magistrate following Matthew, which order was challenged before the Sessions Court in a revision. Revision allowed. And kindly see, revision was allowed without going to the merits of the legality of that statutory notice. Against this revision order, invocation of Article 227, challenge made before the Bombay High Court. And the High Court goes on to hold that once the magistrate records a plea of the accused and the accused pleads not guilty, then the magistrate is bound to take all the evidence which is produced in support of the prosecution. And you cannot turn back or recall and discharge the accused after recording the plea. Now, para 16 of Subramaniam Seturaman, if you see, the judges, they held that the High Court was absolutely right in coming to the conclusion that once plea is recorded, then the procedure contemplated under Chapter 20 has to be meticulously followed, which is to take the trial to a logical conclusion, as has been held by Justice Ramkumar in the 2010 judgment, which was cited by Mr. Gouda. 2010 ILR 2010 ILR 2010 Kerala 145. Now, last year in the suo motu writ petition regarding that section 138 of the Negotiable Instruments Act, that was the constitutional bench decision, which again Mr. Gouda has pointed out. AR 2021 Supreme Court 1957. And Mr. Gouda was referring to a particular paragraph, I remember it is 17, where the constitutional bench goes on to hold that a very close scrutiny of Adalat Prasad and Subramaniam Seturaman, it would show that they do not warrant any reconsideration. Now kindly see, almost like 8 conclusions were drawn in that constitutional bench decision, and conclusion number 6 was this particular conclusion that Subramaniam Seturaman as well as Adalat Prasad lays down the law correctly. And the constitutional bench also reiterated that there is no inherent power for a trial court to review or recall the issue of summons. With the greatest respect, forget the word close scrutiny. There was no scrutiny at all of either Adalat Prasad or Subramaniam Seturaman, except a passing reference which was shown in para 17. So sadly, I have to ask myself, is this how the Supreme Court judgments, which the constitution of our country considers to be the law of the land, should be? Doesn't we citizens have a right to demand judgments which are conducive to much more clarity? And of course, I know that judgments cannot be read as statutes. They are not Euclid's theorem. You can cite ever so many judgments. Of course, I'm cognizant of that. Now, Bhushan Kumar was another judgment which was referred to. Bhushan Kumar, the same Supreme Court actually goes against these 2-3 judges bench. Now, let me ask you one question to this august audience. Suppose the legislature grants an express grant of statutory power. Doesn't such grant of a power carry with it by all acceptable necessary implication that such an authority can use all the reasonable means to make such power also effective? This was first considered by a 3-judge bench in 1969. Income tax officer versus Mohammed Kunyi. AR 1969 Supreme Court 430. I'm not sure about the page number. AR 1969 Supreme Court. Income tax officer versus Mohammed Kunyi. With Justice Grover speaking for the bench. And he held, that was the case under the Income Tax Act. And he held that the Income Tax Appellate Tribunal had the implied powers to grant stay, even though no power has been expressly granted to it by the Income Tax Act. Now, we can see, let us come to this 2010 and 2020. We can see we are having various appeals under the Protection of Women from Domestic Violence Act of 2005. Section 29 is the power which deals with the appeal. Section 29 never grants the Sessions Court the power to grant the stay. But that is implied. That power is implied. So the doctrine of implied power, and we can see, now you can say, see, Income Tax Act or the Domestic Violence Act, of course, even though it is triable by a criminal court, it's a civil remedy. Now, this particular doctrine of implied power that was used to interpret even the CRPC, Savitri versus Govind Singh, AR 1986 Supreme Court 984. That was the case under section 125 of the CRPC. And the Supreme Court says, see, the power which is interim relief. And kindly see, again in Sakiri Vasu also.
Interim maintenance.
Interim maintenance in 1986 Supreme Court. And Sakiri Vasu 2008, Volume 2 SCC 409, 156.3 of the CRPC. That was considered. And the Supreme Court says, yes, there is an inherent power. Because express grant of statutory power carries that you can take all such necessary steps which is essential or required to ensure that you can take it to a logical end. That is the theory of this implied, or else if you merely say you are having only this power, you don't have the other implied power. Now I would invite this august audience attention to the judgment of Justice Sadachivam, which was cited by Mr. Gouda, Bhushan Kumar, 2012, where it was held that it is inherent in section 251 that when an accused, he appears before a trial court, pursuant to the summons which is issued under 204 in a summons case. Now the trial court, the trial judge has a bounden duty. You have to carefully go through the allegations which are made, either in the charge sheet or the complaint, that was the word used in the which were displayed, and then consider the evidence and come to a conclusion whether or not offense is committed or whether or not the commission of such offense is disclosed. And kindly see what the Supreme Court said. If the answer is an affirmative, let the magistrate explain the substance of the accusation. And if not, he is bound to discharge. Of course, what was considered was section 239. Kindly see the statement of the Supreme Court. Supreme Court says, then you are bound to discharge the accused as per section 239. Undoubtedly, this particular ratio, in my humble opinion, raises more questions than it answers. Now, let me explain myself. Now, if you look into the facts of this Bhushan Kumar, you see that the court was considered in section 420 IPC, punishable up to 7 years, and therefore a warrant case, not a summons case. In such factual background, would I be wrong if I say that a discussion on section 251 CRPC, it was a bit inapposite, as it applied only to a summons case? Secondly, in the context of a summons case, the applicability of the word discharge and section 239 CRPC, isn't that questionable? This is because section 239, that figures in a separate, or I would say a dedicated part A of chapter 19, and applies only to the trial of warrant cases, not a summons case which we have in chapter 20. Now the case before the court was a warrant case, and in a matter triable as a warrant case, the possibility of discharge, that can never be questioned. How can you question the possibility of a discharge in a warrant case? It is already there in the statute. And as such, the question as to whether the magistrate is empowered to discharge an accused in a summons case, that never really arose before the court in Bhushan Kumar. Now, Bhushan Kumar was considered only with regard to two facets. One was whether taking of cognizance of an offense by a magistrate is the same as summoning an accused to appear. That was the first question. And the second question was whether the magistrate, while examining the question of summoning an accused, he is required to assign the reason for the same. If you read paragraph 5 of Bhushan judgment, you can see that these were the two questions with which the Supreme Court was concerned. But the highest seat of justice in the country laid down a ratio overlooking both the three judges bench in Adalat Prasad and one in Subramaniam Seturaman. Now, another judgment which was cited by Mr. Gouda was Krishna Kumar Warrior versus Sher Shoppe. It's a 2000 judgment which you see in that Amit Sibbal's judgment. Arvind Kejriwal versus Amit Sibal. Now, Krishna Kumar, that again was a case which was dealing with 420 matter. Very short judgment, hardly less than 10 sentences. And it holds that if an accused or some other person raises some objection that the trial court has no jurisdiction in the matter, then he has to file an application before the trial court instead of rushing before the higher court. And Arvind Kejriwal, Justice Midha, followed that particular judgment. And a host of decisions of the Delhi High Court as well as the Supreme Court were cited. And very sadly, when this comes before the Supreme Court, the challenge made against the Delhi High Court's judgment, nothing was said rather than the Supreme Court remitting back that particular case to the Delhi High Court for further consideration. Now, please see, Adalat Prasad and Subramaniam Seturaman, which according to the Constitution bench does not require any consideration, according to the Constitution bench in the 138 NI Act case. Now, please see, Adalat Prasad and Subramaniam Seturaman, what did it say again? It holds that the only remedy, kindly see the word, the syllable only, the only remedy which is available to an aggrieved accused is to invoke 482 CRPs, which again in my humble...
397. 397.
Exactly, sir. Because right from Amarnath, we are having a host of decisions. Amarnath held, then Madhu Limaye, where you see what is an intermediary order. Then B.C. Shukla is a 4-judge bench. Then you have Urmila Devi versus Yudhvir Singh, 2013, 15 SCC 624, which decided exactly on the issue whether an order taking cognizance and issuing process under 204 that is amenable to revision under 397. And surveying
99 Supreme Court also.
also. Dhariwal. I should come to that. Dhariwal because that is why I said the name of the judges.
99 Supreme Court, 2 decisions.
Two decisions. Dhariwal is 2009. I should come to Dhariwal also a bit later. Now I was referring to Urmila Devi versus Yudhvir Singh. That's the 2013 judgment. Now that considered whether a summoning order under 204 CRPC that is amenable to the revisional or the revisory jurisdiction. And it was held that such an order which is issued by a magistrate deciding to summon, it is not an interlocutory order. It is an intermediary or rather a quasi-final in nature. And being so, it is amenable to the revisional jurisdiction provided under section 397 with concurrent jurisdictions both for the Sessions Court and the High Court. Now, which is for the aggrieved party to work out. Now, I can give you a conflicting decision also on this point. Nupur Talwar versus CBI, 2012, 11 SCC 465, 2 judges, were Justice Patnaik. He went on to say that it is a merely procedural order issuing summons and it is not revisable. Now, if you come to Girish Kumar Suneja, Justice Ram Kumar's favorite judgment, AR 2017 Supreme Court 3620. Now, the concept of an intermediate order that was further elucidated after discussing Madhu Limaye and a number of decisions. Justice Lokur, he goes on to observe that 2 such intermediate orders comes to mind. One is an order taking cognizance and summoning an accused, and the other is an order framing charge. 2017 Supreme Court says. Then you had the 2018 Asian resurfacing of road agency decision. That also says so. Now kindly see, Dhariwal, which just now Mr. Gouda has put in. Kindly see who was the judge here. Now Dhariwal Tobacco was the state of Maharashtra. That was a 2009 judgment. 2009 2 SCC 370. Kindly see. Now the same Justice S.B. Sinha, who was a party both to Adalat Prasad and Subramaniam Seturaman, 2004, 5 years thereafter, in this Dhariwal judgment, his lordship would go on to say that even though there is no provision to discharge an accused in a summons case, dual remedies are available. One is to invoke 482 and the other is the revisional jurisdiction under 397. Now in para 14, the same Justice Sinha goes on to hold that it is wholly preposterous. Kindly mark these words. It is wholly preposterous to hold that Adalat Prasad, as far as it related to invoking the inherent jurisdiction is concerned, it did not lay down good law. You can see in para 14 of this Dhariwal judgment. Now, let this judicial divergence, which leads to this entire confusion, let this be settled by the Supreme Court once and for all. And this is my most humble view on this particular subject. And thank you all for a very patient listening.
Please, Prem.
Yes.
Please come to paragraph 6 of the Constitutional Bench judgment. One more area you would explain and cover. Para 6.
Para 6. I don't have the judgment right with me. Chairman, can you just put it?
Please, I will read that. I have taken it.
Yes, sir.
So, judgments of this court in Adalat Prasad.
Yes, sir. That was a passing remark.
No,
it did not see.
No, not that. Second part of that direction.
Yes, sir.
On reiterated, there is no inherent power of trial court to review or recall the issue of summons, right? The next
Yes.
line, this does not affect the power of the trial court
328.
322
Right.
to revisit order of issue of process
Hey,
in the
Sir,
322 say that at all.
no, it has no application at all. Kindly see that
322 speaks of a different
of
situation.
a different
different
situation.
context.
Of a different
So,
situation. True,
322 never empowers the trial court
true,
to
true.
revisit the issuance of summons.
See, sir, this is a constitutional decision, and we are all citizens who are bound by these decisions. Kindly see,
See, we are
and that to be a constitutional bench.
What is that citation, Prem? I don't have that citation.
Mr.
Constitutional
Prem,
bench citation.
we are
2000
bound by the decision.
2020. So you are speaking about this thing, right?
Constitutional bench.
2021, year 2021 Supreme Court, 1957. Nagamatu sir, am I right?
Yes, you are right. You are always right.
No, sir.
He is not a contradictive.
I am very
And
bad
that-
in following the precedents.
You know
And-
what?
And Nagamatu sir, kindly see who are the judges. Who are the
Right,
judges
right.
in this court? Kindly
Yes.
see
Nice of it.
and kindly see how selection of judges are made.
In fact, I was sitting when the argument was being advanced and by the amicus curiae. So this is a judgment 322. How 322 can empower
Correct.
the order issuance of summons?
Correct, sir.
As
Correct,
you
sir.
said, we are bound by the constitutional judgment, but we are not bound to change our views. We are free
True,
to
sir.
hold our views.
True, sir. True, sir.
See, many cases go like this only. What to do?
True, sir.
In fact, if Adalat Prasad and
Thank you, sir.
Sethuraman hold the field, then in the same year of KM Matthew, 1992, Supreme
Brother
Court.
Ramkumar, you are not audible.
I'm not
He's
audible.
audible, sir. He's audible. Yes, sir. You're audible.
Something wrong at the end of Nagamuthu, sir.
Ramkumar, sir, the thing
Yes.
is that
Yes.
there was a 56 Supreme Court judgment, AR 1956 Supreme Court 460, if I'm not wrong,
Yes.
which says undue servitude to the bondage of precedents. That was deprecated by the Supreme Court.
Yes.
And reference to that reported case is only by way of an illustration, not by way of an appeal to a precedent, because facts of cases cannot be similar. And each
Exactly.
case has to depend on its own peculiar facts.
No, what I was referring to was, if Adalat Prasad and Subramaniam Sethuraman hold the field, then it was in the same year of KM Matthew, 1992, that the Supreme
Absolutely,
Court,
sir.
that the
Absolutely.
Supreme Court held that an accused person who has pleaded not guilty and trial has started, he can plead guilty. That means he can go back to the earlier stage.
Earlier stage.
How is it possible? If no review is permissible, and if there is no inherent power to go back to the earlier stage, that is also in 1992 Supreme Court said. And Kerala High Court has also followed that. Even
so the-
after pleading not guilty and trial, even the trial, when the trial has come to a fag end of the trial, he can still plead guilty, go back to the pre-trial stage.
And so the power of review and the power of recall, both are entirely different.
Exactly.
Review is something else. 362 can never be applied, as said by the Supreme Court. 362 operates on a separate field altogether. This can never be a review.
It is not applicable in respect of our interim order. There ends the matter.
Exactly.
Correct, sir. Correct, sir. Because I was placing my case before a full bench.
This full bench agrees with you.
Is it FUL, Mr. Prem? FUL?
It is FULL.
Thank you.
Sir,
No,
I
you,
think,
is it not? F?
sir, I think Shoaib is waiting with a question. Please,
Thank
Shoaib.
you. Thank you. Thank you.
Sir.
Please
So,
allow me to leave, please. Thank you. I take your permission.
Sir. Yeah, Shoaib, please.
good evening, sir. So my question is, in a complaint case, instead upon a summons, there is no provision for discharge that is there in the code. What if the accused moves the petition under section 259, stating that his summons case be tried as per the procedure of warrant cases and thereafter seeks discharge under section 245?
Come again? Conversion. You are asking of conversion.
Sorry?
You are asking of conversion, converting the summons trial to a warrant case.
warrant case, and thereafter seek discharge under section 245.
See, after conversion automatically, after conversion, then automatically that is governed by the chapter to the warrant cases.
Yes.
Once conversion is done, that's a different aspect. Then the accused has a right. You need not even ponder upon this.
But accused cannot make a request to convert and then give him a discharge.
Correct. Just like the Supreme Court said, consequential order has to be passed.
Just for the sake of pleading a discharge, he cannot request the magistrate to convert the case.
True.
So what I mean to say is that if in the course of trial, a legal difficulty crops up. Suppose the legal notice under section 130 has not been properly served or it is not within time, then he may file an application under section 259 praying that this case should be tried as a warrant case because there are some legal loopholes, and for which, if this conversion doesn't take place and I don't seek discharge, I have to face the whole ordeal of trial.
No, kindly see, you are speaking of what kind of cases? Statutory notice in a 138 matter.
For example, in a summons case, basically.
In a 138 matter, you are saying, can you go and say, convert it into a warrant case?
Because there are certain legal infirmities which cannot be cured by any way, and so I have to face the whole ordeal of trial.
Unless there is 420 also. I don't think it is possible. 138, how can that be converted as a warrant trial?
138 is a summons case, that is settled law. Under 259, I can make a prayer before the magistrate.
See, what does 259 say? Please read the provision. When in course of the trial of a summons case relating to an offence punishable with imprisonment for a term exceeding 6 months, it appears to the magistrate that in the interest of justice, the offence should be tried in accordance with the procedure for the trial of warrant case. Such magistrate may proceed to rehear the case in the manner provided by this court for the trial of warrant cases and may recall any witnesses who may have been examined. If it is during course of the trial of a summons case, it is for the magistrate to do that. Accused has no right to insist, please convert this summons case to a warrant case, because summons case does not permit for a discharge. So if you convert into a warrant case, I can go for a discharge. So please do this.
You mean to say that it's the suo motu power of the magistrate?
It's the suo motu power. Of course, the accused has a power to moot, even though any power, any suo motu power, kindly see, revision, it's a suo motu power. But the revision petition, it is mooting the court. Now, please exercise the suo motu powers.
Except an appeal. Except an appeal.
True,
Appeal can be filed only by a person aggrieved.
True.
But a revision or 482, it's all inherent power, which the parties may invoke. Request the High Court to exercise that inherent power.
Absolutely true.
But then so the accused person will have to go through the entire ordeal of trial then.
Even otherwise, you are undergoing the ordeal of a trial. Why do you call it the ordeal of a trial? There is a trial.
Okay, sir. Thank you, sir.
I think if there are no further inputs, may I request KVJ Rao sir for the concluding remarks.
Good evening, everybody. Gouda sir, excellent presentation. You set the cat amongst the pigeons, and we could see the net result is that for 2 hours you're trying to catch the pigeons and not able to go through it. The fundamental flaw is no definition for taking cognizance exists in the book. And that is where this whole problem arises. I mean, I'm a small man compared to legal luminaries like you, but me having fought the system for the last 12 years from the outside, my observation has always been that there are so many contradictory judgments passed that both the sides, the respondent and the defendant, have a open playing field for a lot of things. Having said that, it is true. Now, once it goes to 204, how do you recall everything is the conundrum that we are trying to find an answer for. And as Justice Ramana said, that the only recourse lies for 482, and he's rightfully said, how many poor people can go to the High Court under 482? With due apologies to everybody, 482 is only for the rich, sir. Because they will go get a stay order it's a shoot and scoot system, sir. The rich will go to the court, obtain a stay order, and will never come back to that court, and the registrar will never register the list that matter for the next 10 years. I can assure you of this, sir. And I've been a victim of it.
An advocate of Kerala, an advocate of Kerala who wrote this was hauled up for contempt. Confirmed
It's okay,
by the
sir.
Supreme
Sir,
Court.
I am waiting for that day, sir. Thrice I've been already taken to the Chief Justice of the Bombay High Court, sir.
My nameland, what's the same name?
Namesake.
Namesake, exactly.
No, I have been
only initials differ.
Yes.
Yeah.
Absolutely.
Not only
Sir, I
initial.
have been
K.
taken
Ram
twice.
Kumar.
One A, yeah.
One A is missing in my case.
I have been taken thrice before the Chief Justice on the same issue, sir, of Bombay High Court. So it is nothing new to me now. Because I have got nothing to lose, sir. Because I am not a practicing lawyer. But practicing lawyers have a lot of difficulties when they come to the court because they are worried of their next client. They're not worried about themselves. They're worried of the next client and they have to bow down before certain, I wouldn't say illegalities, but certain whims and fancies of the bench. So today what Justice Gouda has said is very true. Like I said, I am a victim of a trial that has not begun as yet. 2012 till today. And every time I go before the magistrate and I said, sir, section 66 has been repealed thanks to me only, and it's still on my charge. He said, no. And I said, I'll make an application to remove. No, don't do it now. Let the police do it. The police are saying you bribe me and we'll do it. So where do I go? After having gone right up to the Supreme Court and got 66A repealed through Shreya Singhal, I'm still facing a trial. And the only section against me is the 4th section where the Sessions Court has said that 67A has been written by hand in his order, only to see that he doesn't get bail. So we are facing, I mean, as Prem sir said, like, I mean, even as I speak now, sir, we have a conundrum in the Supreme Court. A 3-bench judge has found that one of the magistrates is in contempt and issued a contempt notice. One of the judges sitting on the 3-bench comes back to a 2-bench and the 2-bench overrules the 3-bench. So where do we go? So the conundrum, if legal luminaries like you are facing this conundrum, imagine a layman standing outside. It becomes, I appreciate it becomes very difficult for a lawyer to explain that to a layman who has not seen the law, because I face them every day. So many of my colleagues say, sir, but why this, why that? I said, no, this is the law and this is how it goes. No, sir, my lawyer didn't argue right. I said, how do you know your lawyer has not argued right? Let's read the order. So what happens is, because of this conflicts in judgment, it is the lawyers also that get a bad name, saying that our case has not been presented properly before the magistrate, before the judicial officers or whoever it is. And again, I said this is one platform. I mean, you can speak freely. I mean, you're not scared of saying anything. I mean, there are no restrictions, and that makes this very, very interesting to come onto this platform, sir. And the legal luminaries that have come onto this platform so far, thanks to Shyam sir, I mean, it's really great. And I once again thank Shyam sir, I thank Gouda sir, and I thank all the legal luminaries, Ram Kumar sir, Justice Ramana, everybody for being here, speaking their mind. I mean, on this is one platform where speaking the mind has not been restricted. And that is the beauty of this platform. And I thank everybody here who's come here, spoken, asked questions. And I feel this is also one forum where you'd rather open your mouth and accept you're a fool than keep quiet and live in a fool's paradise. So it's really wonderful and beautiful to be on this platform. And I thank Gouda sir once again, Justice Ramana, Justice Ram Kumar, Prem sir, everybody for the beautiful articulation, the discussions. I mean, nobody discusses judgment so threadbare. as Prem Kumar said, like when a power is given to a judicial officer, he has the power to see that it reaches its ultimate goal as well. But how many of the benches even perform that role?
Correct.
So that is the conundrum that we are trying to break, sir. You know, for me, unfortunately, all my cases have to go under 156(3), and then I am having a fight with the magistrate every second day. So that's okay. I mean, I live with it, sir. I mean, I shouldn't be discussing this, but in Parliament, there is an admitted fraud of 300 crores of the Provident Fund, and the magistrate says, how can I pass an order? So what do I tell them? And he says, you haven't made specific allegations. Sir, this is a conundrum. That is the latest judgment also come out from the Supreme Court. If I have to make specific allegations, they have to be part of the conspiracy. So you want the complainant also to be an accused. And it is, I mean, thanks to Littles, in the last 2.5 years, sir, I have educated myself in a lot of issues. I've been able to argue matters thanks to Prem sir's articulation, Shyam Padman sir's articulation, and Justice Ram Kumar is always there. And like, at least there is a patient hearing to what somebody has to say, whether right or wrong is not the issue. I mean, nobody fears to raise a question on this platform, sir. And that is the beauty of this platform. With that, I just conclude. I thank everybody here for imparting the knowledge, and thank you, Gouda sir, once again. And thank you very much.
Thank you, Rao sir. We have Arshad Khan, another wonderful judge.
Mr. Shyam,
Please, Ravana sir, sorry.
Yes, just I want to. Mr. Jagannath Rao, with permission of Justice Ram Kumar, I want to say one thing.
You don't require my permission.
No, because I think being an elderly gentleman, I think I require your permission to say one thing. Mr. Jagannath Rao, please don't use such words like legal ruminaries. After all, we are all learners.
Absolutely true.
There is no luminary here.
Sir, but sir,
Okay.
I'm comparing you with myself, sir.
No, please bear with me.
We are all students.
What is there in our mind?
Sir, we are learning every day, sir. I don't dispute that.
No, Mr. Jagannath Rao, I'm something like on sabbatical for last 6 months almost.
Okay.
I'm just to catch up with everyone, trying to catch up with everyone.
Thank you, sir.
That's why I've been very, very eagerly waiting for this type of platform. And Shyam is always there to accommodate me. And Prem also. Anyway, I'll have advice of Justice Ram Kumar always. No issue at all.
Thank you, sir. Thank you.
So I'm just trying to come back to the stage. It's only my attempt to come back to stage. I'm making use of this platform. Okay.
Yes.
So
In fact, in this platform,
my request once again is not to use this type of okay.
I stand corrected, sir. I'll take the correction.
No, this
even
only my request.
I have been taking exception to the address, your lordship, etc.
Yes, even you don't say justice, not necessary.
Exactly.
We're all formal judges, of course.
And this platform, we are
No,
not bound by.
Yes, Indian Republic is grateful enough to give us that title, justice. Okay. We are grateful to Indian Republic. That's it.
Thank you, sir.
In this platform, we are not bound by precedents.
Yes.
We discuss the law in pure and simple.
Yes.
Without bound by any precedent.
Yes.
Very true, sir.
Sir, normally I don't bother about presidents, sir. That's my habit. I don't bother about presidents because I know a small change in fact situation.
It's always
Can
there.
make a lot of
What
difference.
is the configuration?
Very true,
That's my view, firm view always.
Very true, sir.
But at the same time, At the same time, we shouldn't forget Article 141 also.
Yes, the discipline is there. Discipline is there. We are bound
That's
to.
a law of the land.
Yes.
Sir, may I request Arshad Khan, sir, please, your inputs.
Good evening, sir. Actually, the section 259, we have to look into it again, because what we are discussing is in a summons case instituted upon a complaint. After 251 stage, we are actually in a deadlock. So 259 is the only possible way to discharge an innocent person unnecessarily dragged into the court. Why? Because even if he goes to the High Court, under 482, he will get a relief only if there is nothing to proceed further. So if the judge and the accused are convinced that there is nothing against him and he was unnecessarily dragged into the court, why can't we invoke 259 and convert the case into a sessions case instituted by through a complaint and invoke 245(2). Actually, in Adalat Prasad also, what the Supreme Court actually missed is 245(2), because it was a warrant case instituted upon a complaint. And 255(2) allows the magistrate to discharge the person then and there. So 259 is applicable only in a case which is punishable more than 6 months. But suppose if we go to the cases filed by way of complaint, in almost all cases it is punishable exceeding 6 months. So the present code provides only 259. And there is no need to file an application. The advocate can indicate that if the court is convinced that there is no ingredients to proceed further, but we are in a deadlock because we crossed the 251 stage, then instead of sending him to 482, why can't we convert the case into a warrant case, then apply to 45(2)? That is my doubt.
See, if you read 259 again, of course, I saw another thing in that. When you read, when in course of the trial of a summons case relating to an offence punishable with imprisonment for a term exceeding 6 months, if it appears to the magistrate, now the next word after the comma, the next word within to the 2 commas, that in the interest of justice, see why? In the interest of justice, the offence should be tried in accordance with the procedure for trial of a warrant case. So, what is the criteria? The criteria is interest of justice.
Yes.
Now, the simple question would be whether interest of justice requires conversion or not. It is for the magistrate to decide. The criteria, of course, what the wise legislature has enacted is in the interest of justice, which is a very, very expansive word.
Yes.
No doubt about that. But the thing is that, do you think that our courts would take that expansive meaning? That's because we have to be practical.
Yes.
If we argue this position, maybe the provisions of under the CRPC for sending a lunatic into the asylum also can be invoked.
No, what I'm saying is there is an option.
Absolutely true. Absolutely true. Because the criteria is interest of justice. Absolutely true. Interest of justice.
Because if an innocent person is unnecessarily forced to face trial, that is in the interest of
why allow 251 to be crossed?
Crossed,
correct. Allow section 251 to be crossed.
Unfortunately, it is crossed because
why? Why? There the accused is represented by a lawyer.
Lawyer, correct. Because at the stage of 251 itself, you are having that right.
Right.
Kindly read 251. 251
Yes,
also says, when in a summons case the accused appears or is brought before the magistrate, the particulars of the offence of which he is accused shall be stated to him, and he shall be asked whether he pleads guilty or has any defence to make, but it shall not be necessary to frame a formal charge.
So
even
there
the
are
stage
no particulars. There are no particulars
to read.
To be read.
Absolutely true.
But unfortunately, we should see from the angle of sending that person to 482, because 482 will be allowed.
Not necessary.
Only if there is
you can get him a dropping of the proceeding at 250 prior to 251 itself.
Sir, yes, sir, I agree. But unfortunately, 251 crossed. but
allowed it to be crossed.
No, Mr. Arshad Khan is perfectly right in saying that. Why? Because, see, the CRPC pertains to 1973. Of course, it comes into effect during 1974. At which point of time, Article 21 did not consider with the right to a fair trial. That comes later. So it was prior to that concept, the legislature enacts the law.
Any interpretation will relate back to the constitution.
Absolutely true. But this is also a problem because when he says, because the word used is in the interest of justice,
Justice. Right.
unlike any other provisions. When I reread, of course, what you said, when I reread, there is something what you said, correct? In the interest of justice. Because it's a very expansive word. But again, as Mr. Rao, has pointed out,
Within the
no
sweet will of the magistrate.
of course, judicial officers may advert to that fact, provided you hire big guns.
Absolutely.
Okay, we'll wind up.
Thank you, Arshad Khan sir, for that wonderful input. And as we come to the end of this session, let me thank the speaker of the day, Virupaksha Gouda sir, who is a part and parcel of our family, who was addressed us earlier and is a regular participant in our webinars. Thank you very much, sir, for the wonderful way you ignited the thought process and the debate. It was really wonderful. And especially the Delhi High Court decisions with which many of us were not acquainted with. I mean, we didn't really, really look up those things. It was really wonderful that you could bring it to the notice of this group. And Ramkumar sir, thank you very much. And thanks are due to Justice Ramana sir, Justice Nagamuthu sir, and all of you who have constructively participated in this debate and deliberations. And till we meet next time with yet another debatable issue or a question that requires a relook, an issue which requires a relook. Till then, let us say goodbye and please do take care and stay safe. Thank you very much, all of you.
Bye. Good night.
Thank you so much. Night.